Hello, I'm Walter Haines with United Employees Law Group. This message is one of a series designed to expose common errors and violations engaged in by companies that have shortchanged employees out of tens or even hundreds of thousands of dollars in overtime pay and related violations. Having prosecuted well over 700 labor cases, of which more than 70 were class actions against Fortune 500 companies, we discovered that most of these errors and abuses went unchecked over time because employees counted on their employers or the government to protect them. Unfortunately, this has allowed some employees to suffer major losses. We at United Employees Law Group have created this series to help you recognize some of the common violations we have prosecuted. This series is designed to give you insight on your employment rights. In this part of our series, I will be explaining some of the more common miscellaneous exemptions that employers may implement to attempt to disqualify the employee from receiving overtime pay. In addition, I will touch on a few common wage orders that are used by employers to exempt or limit employees from qualifying for overtime pay. These employees who are in sales and who are paid commissions are treated differently and may not be entitled to be paid additional overtime for the long hours worked. The rules that allow these workers to be exempt are very specific and can easily be violated, resulting in the underpayment of a person's wages. Adding to the complexity is the fact that circumstances can easily fluctuate week to week, such as the amount of commissions earned for each pay period. And the first question that must be asked is whether the compensation received by the employee is correctly classified and whether or not it should be treated as commission. The Labor Code defines all the requirements, and if these requirements are not met, then this exemption from overtime fails. By way of example, if an employee receives a guaranteed draw against commissions, then these payments may in fact be payment of a salary rather than commissions. If this occurs, then the sales exemption cannot be applied, and the employee is entitled to all of his or her overtime pay. We have seen substantial underpayments because the rules are different depending on whether the person works in an office, which is classified as inside sales, or travels outside the office, which is treated as outside sales. This is important because those working more than one half of their time in an office must receive at least twice the hourly minimum wage per pay period. This requirement for exemption from overtime does not apply for outside salespersons. There is an additional twist to the above rule for employees who are considered to be classified under the rules as either professional or retail. In these situations, such workers must be paid at least 1.5 times the minimum wage, not 2 times, and more than 1/2 of their earnings are from a valid commission structure. The rules for exempting these earnings vary depending on whether or not the sales are considered to be retail sales. Employees have erroneously been treated as exempt and not entitled to overtime pay in situations where selling is incidental to their main job. Examples of this can be found where the employee is primarily involved in the delivery of goods or repairs or maintenance. If this is the case, overtime laws apply and the employee is entitled to extra pay. There is a special exemption for caregivers who directly care for children or those who need help in day-to-day living needs. These services are provided at home and not at a residential care facility. Small variations from a strict set of rules may void the exemption, resulting in liability for payment of back wages, penalties, and interest. If the type of work an employee does is limited to the direct needs of the patient or child, the exemption from overtime will apply. Examples include helping the person get around, bathing, providing meals, and managing personal finances. This is a very narrow exemption in that it relates directly to the needs of the patient, not to the general living conditions of the household. Therefore, general cleaning or maintenance of the home is outside the scope of work that is exempt, and if these tasks are also performed for more than 20% of the time, the exemption is lost, and any overtime must be paid. For those employees, such as resident managers of a home for the aged that have less than 8 beds, are not entitled to daily overtime after 8 hours in a day, but are entitled to weekly overtime after 40 hours in a week. A personal attendant employed by a not-for-profit organization is not entitled to daily overtime, but is entitled to receive weekly overtime. Facilities that house the sick or disabled are permitted to institute a 2-week period for overtime. That is, the employee does not receive overtime until 80 hours are worked in a 2-week period. The employee is still entitled to overtime after 8 hours in any day. Employees must agree to such an arrangement prior to starting work under such a schedule. Because of the complexities and the subtleties of these exemptions, it's difficult for an employee to know if his or her employer is applying the law correctly. The key here is to know when to seek an unbiased analysis of your situation. If you suspect you've been misclassified, take a couple of minutes to talk to an experienced California labor law attorney and find out what your rights are. This video is part of United Employees Law Group's effort to provide useful information and strategies to protect your rights and to level the playing field. Thank you, and I invite your comments.